Yes, Mr. Daniel.
Your Lordship, may I seek indulgence in mentioning part 2, item number 6. This case is taken by my senior Miss Mary L. Kiengte. May this matter be taken on 4th
I don't
June.
know the part 2. Part 2, item 6.
Yes, Your Lordship.
What do you want?
This matter can be, if this matter can be taken on 4th June.
Mr. Liama,
I'm for the
Lianga?
appellant, my lord.
Huh?
I'm for the appellant.
Okay, as prayed for by Mr. Daniel, learned counsel appearing on behalf of MS Mary, learned APP for the state respondent, which is not opposed by Mr. Klianga, learned counsel appearing for the appellant, repost on such and such date.
Obliged.
4th June.
And Your Lordship, item number 11. I've taken the consent of the other party.
I'm for the appellant, my lord.
Can this matter
Same. Here you just khali put Lal Fakjwala for the appellant.
My lord,
On-
may it be fixed on 2nd June.
Yes, Your Lordship.
Obliged.
Second, all right?
Yes, Your Lordship. And Your Lordship, item number 12.
How many?
Only the one now.
And 12 for the for the appellant's name would be Mrs. Lalsami.
Yes, let me sorry.
Correct?
Yes, I've taken the consent of the other party. After a week.
Okay. Same order. Huh?
9-6.
Yes, Mr. Pautu.
Oblige, Your Lordship.
Seek to mention item 9 of part 2, though the matter was fixed for today, my lord. The councils have consented that the matter be taken up on another day.
All right. In fact, I don't know whether the court would also have time for a new appeal, because I'm in the midst of a writ petition hearing yesterday, which I'm proposing to give dictation. I think Mr. Joseph's matter. So anyway, so when do you want it?
After 2 weeks, my lord, because yes, so that there is ample time
This
for
is item
preparation.
number?
Item 9 of part 2.
Item 9. As jointly prayed by Mr. L. Pautu, learned counsel for the appellant, as well as MS Linda, learned PP for the state respondent, repost on such and such date.
16-6.
I'm obliged.
My lord, item 5 of part 2. This is a state appeal. If this can be adjourned after 3 weeks, my lord.
As prayed for by MS Linda, learned PP, which is not opposed by the other side, repost on such and such date.
23-6.
Obliged.
Daily list. Item number 1.
Yes, Mr. Victor, it's a contempt.
Yes, my lord. Although it has been listed as motion, my lord.
First day,
No, my lord. Notice was already issued on 23rd of April. Inadvertently, it came to the motion column. And as per this court's order, my lord, I have taken steps upon all the respondents.
steps complete.
As per the office note 25-5, my lord, they have received on 27th April by all the respondents an ID card returned back from respondent number 2.
No, but then that means AD, yes, you are appearing for?
Your Lordship, I appear on behalf of CGC Zarim Sankwi.
Sankwi.
Yes, Your Lordship.
But you are appearing for which respondent?
Respondent to
R2. And your name?
Lian Ming Tanga.
Thanga.
Yes, Your Lordship.
What about the other respondents? Because Mr. Victor, if you see the 25 note, it says postal receipts have returned from all respondents. Then it says duly signed AD card has returned on so and so from R2. What about
We may await for service report.
no, let me see where are the postal receipts of 1 to 6. It's kept in C file. Receipt. No, there must be a signature, no? This is Rajiv Dua. Who's Rajiv Dua?
He was the previous chief engineer, my lord. As on day, my lord, there is a new incumbent, which I will be taking necessary steps for implement of the new incumbent.
You have already taken,
I have not yet.
but
I was-
he's already acknowledged.
During that point of time, he was the present as chief engineer.
What is this? This is some application. They're just the requisite details, but These are not AD cards, no? These are not AD cards. So let me ask the office to verify. Heard Mr. Victor, learned counsel appearing for the petitioner. Also heard Mr. Lian Hem Kangla, learned counsel appearing on behalf of MS Sangpui, learned CGC for respondent contender number 2. Office note dated 25/5/2026 indicates that notices to the other respondents in respect of notices to the other respondents, postal receipts thereof has been returned. However, this court could not locate the AD cards as whether the same has been returned back upon duly being served upon the aforesaid respondent contemners. Let registry verify and place an updated status as regards the service of the contemner respondent numbers 1, 3, 4, 5, and 6.
Your Lordship, I may also pray for 3 weeks time
In the
to
meantime,
file
Mr. So
Aga
and so, learned counsel.
show cause reply.
Yes, I'm giving you. So and so, learned counsel for the respondent stroke contemner number 2 is at liberty to file reply to the show cause received. Repost after 2 weeks, give a date.
16-6.
Deeply obliged.
Item 2 for admission.
Where is his name on? Show me that.
Lordship, both the leading counsel for this item, they are on legs in court number 1. So, my lord, if this matter may be taken up after 2 weeks.
As jointly prayed by MS so and so and MS Ruth, na?
Yes, Lordship.
Learned so and so repost on such and such date.
19-6.
Obliged.
Item 3A.
My lord, for the petitioner, Mizoram Rural Bank.
You have not taken steps.
Yeah, my lord, on the last court date, we have submitted, we have made a prayer that we will submit an additional affidavit. So, however, our client haven't supplied us the documents to be submitted along with the additional
No,
affidavit.
additional affidavit is all right, but what about the steps?
Yeah, my lord,
You
apologies.
have not taken steps. As
we'll be
per
taking
office order
steps.
dated so and so, the counsel for the petitioners is directed to take steps of service of notice upon R1, 2, 3, and 4. However, the learned counsel has not taken steps for the same.
Yes, my lord.
So your additional affidavit will come later. First of all, have you taken the steps? If you have not taken
It
it,
seems, my lord, we have not
so
taken
are you
steps.
going to take it, or otherwise
We'll-
I will dismiss it for non
We'll take
for
the
no
steps, my lord.
Huh?
We'll take the steps.
All right. MS so and so learned counsel for the petitioner submits that due to that the requisite steps in respect of the respondent numbers 1, 2, 3, and 4 as directed earlier by this court by order dated 26/2/2026 shall be taken within a period of
A week.
within a period of 1 week from today without fail.
Yes, my
In
lord.
view of the aforesaid assurance, the matter stands posted after give a date after 2 weeks or something on such and such date.
22-6.
In the meantime, the petitioner is also the petitioners are at liberty to file the additional affidavit as directed earlier by this court.
Obliged.
Item 4.
Yes, Mr. Victor. Counter affidavit, Ms. Bani.
Yes, Your Lordship. I'm seeking another 2 weeks' time.
2
to
weeks
file my
time.
affidavit.
Heard Mr. Victor El Ralte, learned counsel appearing for the petitioner. Also heard MS Vani, learned state counsel appearing for respondent number
The sole respondent,
for
Your
the sole respondent. MS Vani seeks further 2 weeks.
2 weeks, Your
2
Lordship.
weeks time to file the counter affidavit. Prayer is not opposed. Repost on such and such date.
19-6. Items 5 and 6.
Yes, Mr. Victor.
My lord, 5 and 6 also I'll have to seek another 3 weeks' time, my lord.
3 weeks.
Consolidated Parabais comments is still awaited.
If I may, my lord, this item number 4, 5, and 6 are analogous matters, similar.
Okay, fine. In item number 5 and 6, both Miss Linda.
Yes, my lord.
Heard Mr. Victor L. Lalti, learned counsel appearing for the petitioner. Also heard MS Linda, learned additional advocate general for the state respondent. Learned additional advocate general seeks further time for filing counter affidavit. Prayer is not opposed. Repost on such and such date.
22-6.
Interim order may be continued, my lord.
In only 5 and 6 or also in 4?
5 and 6, my lord.
In these two matters, interim order, if any, shall continue till the next date of listing.
Deeply obliged.
Obliged.
Item 7, for orders.
Yes, what is this?
May it please your lordship, I am appearing on behalf of my learned senior, Mr. Alam Rota. My lord, an interlocutory...
Impleadment of victim's guardian, of course, we'll allow it.
Yes, sir.
Yes,
You said something about your senior. You want time, or you want the court to allow the interim interlocutory application?
yes, my lord.
What?
At IA 29 for impleadment of
I had to be
IA 29 of 2026 for impleadment of the proposed
heard
respondent.
MS. Your name,
Jail Ramphoni.
got it? For the applicant. Also heard MS Vani, learned APP for the state respondent. By way of this application under section 528 of the BNSS 2023, read with the practice directions issued by this court governing proceedings under the POCSO Act 2012 for impleadment of the the applicant is seeking impleadment of the informant stroke victim's guardian in the connecting criminal appeal, criminal appeal number 6 of 2026. It appears that the applicant, while filing an appeal against the judgment and order dated 13/2/2026 passed by the learned first track special court under the POCSO Act 2012 in special POCSO case number 90/2025 arising out of Dungtlang PS case number 7 of 2024 under sections 10 of POCSO Act 2012 inadvertently did not implead the informant stroke victim's guardian, since the division bench of this court in Deepak Nayak versus so and so has clearly laid down that in cases arising out of the POCSO Act, the victim, the guardian, parent, and or support person is required to be impleaded in such appeals. Subsequently, pursuant to such direction of the division bench, practice directions have also been issued by the Gauhati High Court governing such proceedings under the POCSO Act. In view of the MS Vani, learned so and so, accordingly submits that the victim's guardian be impleaded as respondent number 2 in the present appeal. The interlocutory application accordingly stands allowed. The Srimati Lal Thingliani, wife of Lal Mung Sanga, resident of Khung Thing, the informant stroke guardian of victim X is impleaded as respondent number 2 in the present appeal. Let necessary changes be made in the criminal appeal number 6 of 2023 by the registry. Should I issue notice here?
Yes, your lordship.
In the main appeal that is disposed of, in the main appeal pursuant to the direction passed by this court in interlocutory criminal number 29 of 2026, let notice be issued to the newly impleaded respondent number 2 through the office of the public prosecutor in terms of the practice direction issued by this court. So you do it.
Yes.
Let a report thereof be also forwarded to the office of the public prosecutor through the jurisdictional police office. by the by not
And
through,
Your
huh?
Lordship, a copy have to be
by
given by the applicant.
by the
also.
jurisdictional police station, not through. Okay, full stop. And let a copy of the appeal memo be furnished in the format prescribed under the practice direction to the office of the learned PP, to the office of the PP by the registry.
Through registry, Your Lordship, it has to be Form 8. Registry has to prepare the Form 8.
So that's how I said.
That Form 8 will be sent to our
So,
office.
so what
to
should
the-
I say?
Through registry. Through registry to the,
Through registry.
23-6.
Michael, that impediment, Prakash should do it, and then that order should come here. Huh? That change. Yes, Mr. Liana,
My lord, this is an application for suspension of sentence, my lord.
suspension.
Yes, my lord.
What is the sentence?
The sentence
10 years.
was made under 21C of NDPS Act for an imprisonment of 10 years and
10
fine-
years.
a fine of, yes,
10 years, quite a long time.
yes, rupees 1 lakh fine.
And 21C, commercial
Yes,
quantity.
yes, my lord. My lord, that is commercial quantity.
Yes. On what ground are you asking for suspension?
My lord, here the
In one of the decision of the apex court arising from, I think, NDPS, 7 years, in cases of 7 years where for a long time one is inside and there is no possibility of a trial for the appeal to be concluded. In such matters, of course, sometime it has been given. But those there, the sentences were not more than 7 years. Here it's 10 years.
my lord.
And commercial. And what about the paper book? Is the paper book ready?
Paper book is ready, my lord. Yes.
Then why can't we have it the hearing?
That can also be.
Yes, we can have the hearing.
yeah,
Paper book
that
is
can-
ready.
That might also be possible.
Then I can post the. Will you withdraw the IA then? And have the in that situation you don't go for a dismissal of the IA
My lord. If we
because
can-
the paper book is ready.
Yes, paper book is ready, my lord. And my lord, if we can have a fixed date,
Yes, I'll give you the fixed date. So what do you want to do with the IA?
if we can have a speedy hearing, then I'll go
You're not
for
pressing
that.
it.
I'll go for that, yes.
Okay, fine. In the IA, you say, heard Mr. F. Lalingliana, learned senior counsel, assisted by Mr. MS, so and so, learned counsel for the applicant. Also heard MS Linda, learned PP for the state respondent. In view of the fact that the paper book is ready, is already prepared and furnished to both sides, the appeal itself can be heard. Mr. F. Lalingliana, learned amicus curiae, fairly submits that he does not wish to press the instant IA at this stage. Accordingly, the IA stands dismissed on being withdrawn. And in the criminal appeal, the parties remain same except appellant instead of applicant. Since the paper book is ready and furnished to the learned counsels appearing for the parties, let the matter be posted for hearing on
9, and not 11. Okay.
17, my lord.
17
June.
17 June. 17 May or 17 June? What did you say? I didn't get it. June.
May.
June.
June.
No, not
June,
May. It has to
Cannot be May. Wednesday, yeah.
I think 17 is a Wednesday.
Yes,
Yes.
it's a
Probably
DVD.
you will have a division bench that day.
18 will be fine, my
18,
lord.
my lord.
18.
18.
Item 9.
IA Kamasa, yes.
You want to be changed? You want to be changed? Yes?
Lordship, my senior Mr. Johnny is in another courtroom right now. So
Yes, Your Lordship, in the meantime, I was directed to produce the case diary. However, as per information, the case has been charge sheeted. So in that case, Your Lordship, I believe that we have to call for the GCR.
TCR. So we'll call for the TCR.
Yes, Your
Scan
Lordship.
copy.
Yes, scan copy of TCR.
Your name?
Let mga isa nga.
Heard Mr. So-and-so, learned counsel appearing for the petitioner. Also heard MS Vani, learned APP for the state respondent. Though by order dated 14/5/2026, the learned additional PP was directed to obtain the case diary and produced before the court today. However, MS Vani, learned APP submits on instruction that the case have already been charge sheeted. Let the scan copy of the TCR be called for repost on such and such date.
Deeply obliged.
9-6. Supplementary list, item 10.
This is going to be long. The item 10. It's very long judgment. Are you sure? Or otherwise you can ask Decca to come. You can. Mr. Joseph, you had given just 2 decisions, no? Michael, can you find out if there is a SSC citation for this? Mr. Joseph, while I'm dictating, can you ask one of your junior to just verify if there is an equivalent SSC citation? Huh? The other case that you relied, Pramod Kumar Bajaj's case. Heard Mr. Joseph so-and-so, learned counsel appearing for the petitioner. Also heard Mr. Lian Shrema, learned senior counsel assisted by MS Ruth so-and-so, and Mr. A.R. Malhotra. I'm putting his name, assisted by MS so-and-so, learned counsel for respondent numbers 1 to you are respondent 6, right? So they are respondent number 1 to 5 and Malhotra is 6, R6. By way of the instant petition under Article 226 of the Constitution of India, the petitioner is putting to challenge the alleged illegal appointment of respondent number 6 to the post of registrar in the Mizoram University. Now, the brief facts of the case is that pursuant to the recommendation of the selection committee and approval of the 49th Executive Council of the Mizoram University convened on 17/12/2018, the Vice Chancellor of Mizoram University by order dated 9/5/2019 appointed the respondent number 6 to the post of Registrar of Mizoram University for a tenure of 5 years commencing on 1st May 2019. Upon the expiration of the respondent number 6 tenure to the post of registrar, his services were extended by notification dated 25/4/2024 until a new appointment is made or until further orders, whichever occurs earlier. As per clause 4(4) of the Mizoram University Statute. Stop. Thereafter, by way of an employment notice dated 18/6/2024, applications were invited for filling up of various posts, including that of a registrar. issued by the respondent number 6 in his capacity as registrar. The qualification prescribed for the post of registrar as set forth in the said advertisement are as follows. Page 16. A to A. Thereafter, the respondent number 6, having obtained a no objection certificate dated 8/7/2024 from the head of the Department of Forestry, Mizoram University, comma, to his application for the post of Registrar, Mizoram University, comma, applied to the said post of Registrar in terms of the advertisement dated 18/6/2024. Stop. Correct, Mr. Joseph? So far, facts have correctly come, na? Yes, 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 yes. Yes, yes, perfect. And if you one deca is free, you can come. This is the last matter. Pursuant to the advertisement, the petitioners also applied for the post of registrar, and after participated in the selection process, the petitioners as well as respondent number 6 candidature was held to be valid. Accordingly, a valid list was published. Where is that? Where is that valid list?
167.
The valid list was published on 8/10/2024. In the said list, while the name of the respondent number 6 appears at serial number 4, the petitioner's name appears at serial number 5 and 10 respectively. Pursuant to the nomination of external experts, the selection process was concluded and recommendations by the external experts was sent to the Executive Council, whereafter the Executive Council in its 66 or 66 in its 66th
Meeting. Page 171.
Executive Council meeting
Yes,
held on 5/11/2024
yes.
approved the recommendation of the external experts. Thereafter, the impugned order dated 19/11/2024 was issued by the, who has issued this?
Joint registrar.
By the joint registrar, whereby the respondent number 6 was appointed to the post of the registrar.
Yes.
Aggrieved by such appointment of the respondent number 6, the present writ petition has been filed. Mr. Joseph L. Ralte,
El Renfei, my lord. It's okay.
sorry, Ralte is Victor,
Victor.
I think. Mr. Joseph, so-and-so learned counsel for the petitioner submits that the appointment of the respondent number 6 to the post of registrar is absolutely illegal, perverse, and arbitrary. He submits that the respondent number 6 himself, being the registrar of the Mizoram University, who having appointed the who having nominated the who having approved the nomination of the external experts, comma, participated in the executive council meetings whereby the recommendation of the external experts was approved, comma, the appointment of registrar of the respondent number 6 to such post cannot be said to be premeditated and or without bias. He further refers to the relevant, that was
Page number 66.
66.
Page number 60. Sorry, my lord. Page number 62. 61. 61. I'm sorry, my lord. It's page number 62 only.
No, this starts from the rules, no?
This is the statute.
I got it.
Yes.
He further, no, how did I start the sentence? Yes. He further refers to the statutes of Mizoram University, under which clause 4 clearly provides that if a registrar is unable to perform his duties of his office, such duties shall be performed by such persons as the Vice Chancellor of the university may appoint for the purpose.
Yes.
He accordingly submits that it was imperative for the respondent number 6 to recuse himself from participating in the selection process to the post of registrar, as he himself has participated, as he himself applied for the said post.
Sure.
Anything more submissions? These are your main. In support of his submissions, he relies upon the following cases of the apex court. Did you get that other citation?
No, the other one does not have an SCC citation.
1969 volume 2 SSC 262. You put first the case name and then put the citation, but I'm just giving you, so it'll be easy for you to just write. But first write AK Krepak so-and-so versus so-and-so, then reported in so-and-so. Okay, like that. And number 2, Pramod Kumar Bajes versus so-and-so, reported in MANU stroke SC stroke 0103 stroke 2026.
Yes, this is the Manu citation, and the equivalent neutral citation, my lord, is also provided on the top, 2026. Manu, I think, should suffice.
How do you do that? Equivalent. Which is the, I think the Manu subscription should do.
Should suffice, my lord.
Huh?
Should do.
Or you can put this in bracket. I'm putting it in bracket here. 2026 INSC 101. Per contra, Mr. Nyanshrimal Leonard Senior Counsel submits that the writ petition is not maintainable as the petitioners themselves, having participated in the selection process, cannot challenge the same after having not been selected therein, after having not been appointed therein. On maintainability, that was the submission. I think there was another point for maintainability.
There was one other point they had hinted on, my lord, estoppel. Once you participate, you cannot challenge.
That is this,
This
the same. So this is the maintainability challenge.
So they had mentioned, my lord, that we had not challenged the what do you call it, that nomination.
Correct. He further submits that the respondent number, the petitioner having not challenged the recommendation of the expert counsel to the post of registrar in question, the consequential appointment of the respondent number 6 to such post cannot be maintained by way of the instant writ petition.
Yes.
This was his submission.
This was basically, yes.
In support of the aforesaid submissions, he relies upon the following decisions. Manish Kumar Shahi, 2010, 12 SSC 576. Amarjeet Singh and others versus so and so, 2010, 1 SSC 417. Mr. A.R. Malhotra likewise submits, respondent number 6, likewise submits that the writ petition is not maintainable since the writ petitioners, after having participated in the selection process and having not objected for the respondent number 6 to act as a registrar therein, cannot, after not being appointed to such post, challenge the entire selection on the ground that the respondent number 6, who is the registrar of the Mizoram University, selected himself pursuant to the selection where he was one of the contender to such post. He further submits that the respondent number 6 has not participated in the selection process as contended by the petitioners. It is submitted that respondent number 6 has only communicated the decision of the Vice Chancellor nominating the external counsels to them, and has also, by virtue of him being the ex officio member of the Executive Council, participated in the 66th executive meeting held by the Executive Council for considering the recommendation of the Experts Council for the post of registrar in question. It is, however, submitted that during the consideration of the candidature of the respondent number 6 as an applicant to such post, the respondent number 6 had walked out and was not sitting during such time. In support of his submissions, he relies upon the decision of the apex court in the case of State of Uttar Pradesh versus Karunesh Kumar so-and-so, reported in 2022 SCC online SC 1706. I have given my anxious considerations to the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. I have also considered the citations cited at the bar. The issue arising for determination in the instant writ petition is the legality and the validity of the appointment of respondent number 6 to the post of registrar in question. 5 or 6 is respondent number.
Is 6 and 5 is the registrar.
So I will say 5 or 6 here.
I think it says 6, madam.
6 would be better. Mr. Joseph, yesterday I remember somewhere we saw the prescribed by statutes, and then
Yes.
you showed me
Yes,
something.
yes, my lord. Prescribed by statutes is in the Act, page number 46, my lord. This is section 14(1) and 1(2).
So act is called what?
The
Where do I
Mizoram-
get the
Yes, my
huh?
lord. It's page. It starts at page. The Act starts at page number 39. My lord, is the Mizoram Universities Act 2000. Sorry, page number 37. Mizoram University Act 2000, my lord.
Yes, I got it now. I was that time looking for the name of the act, and I was not getting it actually.
Yes, yes.
And the statute starts from
The statute starts from, I think 59, my lord. Let me see.
59. Yes, I got it.
Yes.
In order to decide the issue, it is apposite to refer to the relevant rules and statutes that governs the powers, duties, functions, and procedure for appointment of the post of registrar. Powers, duties, functions of the registrar. And the appointment thereof. Okay. The Mizoram University Act 2000, hereinafter called as the Act so and so, defines Executive Council under Rule 2I as the Executive Council of the University.
J, my lord, not I, J.
J. Rule 2S defines statutes and ordinances as that of the university for the time being in force. Rule 14, which deals with the post of the registrar, reads as under, quote unquote, page 46, A to A. The statutes of the university which is in force prescribes the manner in which the registrar shall be appointed. Statute 4, which deals with the post of registrar, reads as under. Page 62, A to A. A to A, huh? 62 to 63. Reading of the aforesaid rules and statutes, it appears that the post of registrar is for a fixed term and is appointed by the Executive Council on the recommendation of a selection committee constituted for the purpose and shall be a whole-time salaried officer of the university. It is apparent that the registrar, amongst others, shall have the power to enter into agreement, sign documents and authenticate records on behalf of the university, and shall exercise such powers and perform such duties as may be prescribed by the statutes. Before going to the functions of the registrar as prescribed under the statutes, it is apt to mention that under subclause 4 of statute 4, it is clearly provided that when the office of the registrar is vacant, or when the registrar is by reason of illness, absence, or any other cause unable to perform the duties of his office, the duties of the officer shall be performed by such person as the Vice Chancellor may appoint for the purpose. It is further evident that the registrar shall be an ex officio secretary of the Executive Council, but shall not be deemed to be a member of such council. It is further apparent that amongst the duties of the registrar is the custodian of the records, the common seal, and such other property of the university as the Executive Council shall commit to his charges. The registrar is competent to issue all notices convening meetings of the courts, the Executive Council, the Academic Council, the College Development Council, and of any committees appointed by those authorities. The registrar is further required to keep the minutes of all the meetings of the Executive Council, etc., and to conduct the official correspondence of the Executive Council, amongst others, and also to arrange for and superintend the examinations of the university in accordance with the manner prescribed by the ordinances. That apart, the registrar is required to supply to the visitor copies of the agenda of the meetings of the authorities of the university as soon as they are issued and the minutes of such meetings, and also to represent the university in suits or proceedings by or against a university, and to perform such other duties as may be specified in the statutes, the ordinances, or the regulations, or as may be required from time to time by the Executive Council or the Vice Chancellor. On the face of the duties prescribed under the statute, the word ex officio chairman assigned in respect of the registrar appears to be a misnomer in the opinion of this court. This is what you are saying, na? That he can't be an ex officio because of so much duties. Didn't you say this yesterday?
No, what I was saying, my lord, that his work as an ex officio is part and parcel of his duty as a registrar. That's what I was saying, my lord.
Okay.
I'm not sure how I mean, my lord, that's how I was saying. So I'm not sure how it.
All right, let me deal
Yes,
that later.
yes.
Don't say this ex officio thing, huh? No, that part you delete. Also apt to refer to statute 18, which prescribes the procedure which prescribes the manner the selection committee is to make the recommendation for the post of registrar. 18(1) capital A reads as under, quote unquote, page 73. A to A. Only that part.
Yes.
The rest I don't think is required. Admittedly, in the instant case, the respondent number 6, who was earlier appointed to the post of registrar, upon his term being expired, was reappointed to the said post in terms of subclause 4 of statute 4 of the Mizoram statutes, of the statutes in question. Upon the post having been fallen vacant due to the expiry of his of the term, no, don't say that. Thereafter, the Executive Council initiated a fresh process for appointing a registrar in terms of the rules and statutes. Accordingly, advertisement was issued, pursuant to which, along with the petitioners, the respondent number 6 himself also contended. In such, upon verification of the applicants, both the respondent number 6 as well as the petitioner's candidature stood were found to be valid, and accordingly a valid list was prepared wherein their names were incorporated at serial number
4, 5, and
4,
10.
5
And 10.
and 10 respectively. The problem starts from there, I think. Now, that valid list is not signed by him.
But not signed by him. It was after this.
What follows next? What follows next is slightly shocking, inasmuch as the respondent number 6 himself on 10/10/2024 through his email, within quotes, registrar@mzu.edu.in, This was sent to whom?
To the executive council members.
Inform the nominated external experts that the selection committee for the post of registrar and internal audit officer, Mizoram University, which is scheduled to be held on 23/10/2024, has nominated them as external experts. And in terms of Statute 18(2)(b), the matter is placed before the Executive Council within bracket through e-circulation for approval. Pertinent that the subject featuring in the said email reads as, within quotes, nomination of external expert for selection of registrar and internal audit officer. The double quote registrar, huh? REG would have been registrar, isn't it?
Yes.
Are you sure? In the said email, it was further mentioned that if comments any to be submitted before the registrar, I respondent number 6, via the said email, via email at his office email ID by 17/10/2024, failing which the approval, failing which it shall be considered that the 3 nominated external experts have approved their nomination. This is what, na?
This is what.
Full stop. Thereafter, the external experts having approved their nomination, the respondent number 6 on 18/10/2024 communicated the approval of the Executive Council of the University to the appointment of the nominated external experts, of the 3 nominated external experts. So, thereafter, the respondent number 6 on 11/11/2024 circulated a copy of the draft minutes of the 66th meeting of Executive Council to all members of the Executive Council, Mizoram University, seeking comments, if any, to be sent to him on or before 13/11/2024, and in the event no comment is received within the stipulated time, it will be considered that the minutes has been approved by them.
Correct.
Interestingly, in the 66th meeting of the Executive Council held on 5/11/2024 at 2 p.m. at Administrative Conference Hall, Mizoram University, the respondent number 6 participated therein and was present, which is evident from the list of members present at serial number 12.
He was present and he had also signed the meeting minute at page 177.
The relevant portion of the aforesaid minutes reads as under, quote unquote, you give this 172, 170, you give this part, huh? I'm just giving it, huh? Members, actually don't, that is not required. From at page 173, part 3, only that much. Okay. It further appears that the Executive Council resolved in the aforesaid meeting to approve the recommendation of the selection committee for registrar, Mizoram University, selecting the respondent number 6 for the said post. Where do I get his signature?
My lord, 177.
It appears that the resolution is also signed by the respondent number 6 in his capacity as registrar. Quote unquote, page 177. A to A. And this is 177. There's a typed copy at page 177A in case you want. Huh? Thereafter, the impugned order dated 19/11/2024 was issued by the joint registrar, whereby respondent number 6 was appointed to the post of registrar, Mizoram University, in the pay level 15 plus other allowances as admissible under Mizoram University from time to time for a tenure of 5 years with effect from 19th November 2024. It is mentioned in the appointment order that his appointment shall be governed by the Act, ordinances, rules and regulations of the university as amended from time to time. Raised by the learned counsels appearing for the respondents. It is an admitted position that the appointment of the respondent number 6 was challenged only after the impugned appointment order was issued by the joint registrar. The decisions relied by the learned senior counsel appearing for the petitioner in this regard are contextual.
My lord, it should be for the respondent 1 to 5. You said petitioners.
Sorry, 1 to 5. In Manish Kumar Shahi Supra, the petitioner, who being a candidate for selection to an advertisement issued by the Bihar Public Service Commission to the post of civil judges within bracket junior division, after being declared successful in the written examination and after being interviewed, his name having not figured in the merit list prepared by the Commission, challenged the selection process by way of a writ petition before the jurisdictional High Court on the ground that the marks prescribed for viva voce test were excessive and contrary to the law laid down by the court in a catena of decisions. It was in that context that the apex court has held that the petitioner, after having taken part in the process of selection, knowing fully well that more than 19% marks have been earmarked for viva voce test, the petitioner is not entitled to challenge the criteria or process of selection. That too, after he was not selected in the merit list. The aforesaid Similarly, in state of Uttar Pradesh, Supra, likewise, what did you write, Aki? The last line. No, what did you like about the state of Uttar Pradesh Supra, that case? Wherein the private respondents and the impleading applicants who willingly took part in the selection process, and after finding to their misfortune that their names did not find a place in the list sent by the commission to the appointing authority, challenged the entire selection as illegal as having not been done in accordance with the rules in question. Despite knowing very well that the entire process was done in accordance with the existing rules. Don't, that last line is not required. Stop. Despite knowing. However, the facts in the instant case is slightly different. Here, the petitioners are not expected to know as whether the respondent number 6, who is also the ad hoc registrar, and a contender to the post of the registrar, is participating in the selection process or not. Here it was for the respondent number 6 himself, who ought to have recused himself in participating in the selection of the selection to the post of registrar in question, since he himself is temporarily functioning as registrar to the Mizoram University. He not only participated, he in fact communicated the that will be on merit, that much. Hence, I am not inclined to accept the submissions of the learned senior counsel appearing for the respondent 1 to 5 as well as respondent 6, that the writ petition on that score alone ought to be thrown at the threshold. The further contention of the learned senior counsel for respondent number 1 to 5, that it is the consequential appointment of respondent number 6 which has been under challenge in the writ petition, and not the recommendation per se itself, is also not supporting the respondent in any manner. The prayer of the writ petition, the relief sought in the writ petition, reads as under. Prayer
35A.
30,
35 to 35A.
35. Oh, the writ petition is lying here and I'm finding it.
31 to 31A, my lord.
31.
Starts from 31.
31, yes. 31 A to A, huh? 31 and 30, 31A, it goes on, A to A.
My lord, my lord, let me, my lord, 31A, my lord, instead of writing respondent number 6, by inadvertence we have written respondent number 5. My lord, can we be allowed to correct, my lord?
That's why I said you corrected.
Yes, yes.
In the prayer you say R6, huh? You make that correction.
I'll do in the
with
registry.
the initials.
Yes.
The decision in support of the aforesaid contention in the case of state of Uttar Pradesh, Supra, wherein the apex court has held as under para 21. Huh? Oh no, sorry, not this. That was the other case, no? Sorry. Yes, this one. Case of Amarjeet Singh Supra, wherein the apex court has held as under quote unquote page 28, para 28 at page 426. 426. It is apparent that it is in the context where the appellant had not challenged the promotion but only the consequential seniority to such promotion was held to be not maintainable by way of a writ petition. Such is not the case here. The petitioners is challenging the entire selection process as evident from the prayer itself. The appointment order dated 19th November 2024 is not a consequential order but the very impugned appointment order. The recommendations of the experts commission has never been furnished to the petitioners so as to give them an opportunity to challenge the same. In any case, it is the participation of the respondent number 6 in the entire process which, vitiating the selection, the petitioner is challenging the selection process. That being so, I do not find any substance in the arguments of the learned counsels as regards the maintainability of the writ petition. Turning to the merits of the writ petition, turning to the merits of the issue in controversy, it appears that the respondent number 6 has all along participated in the selection process. In A.K. Krapa versus so and so Supra, the apex court has held as under para 9. Para 10, 11, 12, 13, 14, 15, 16, 16, na? Similarly, in Pramod Kumar Bajaj, the apex court has held as under. Which is that paragraph you
My
were
lord, I
relying?
think in this one, I think paragraph number, the last part,
43.
43, I think that should be enough, my lord.
Para
Especially
43.
the last part of 43, my lord. Yes,
43.
43 should be enough.
43, 44 and 45 also. sorry, give it till that. No, you don't need 44 and 45, only 43. It's a long paragraph, huh? There cannot be any sorry, don't say that. Though the learned count, though a stand has been taken, though a categorical stand has been taken in the counter affidavit filed by the by the respondent number 125, did they take that stand or not that he is walked?
They took, my lord, paragraph 20, I think.
By the respondent number 6.
Paragraph 22.
20?
22, paragraph 22.
Of which affidavit?
Affidavit of respondent numbers 1 to 6. Sorry, 1 to 5.
Um, 1 to 5. That the respondent number 6, though was in attendance in the meeting, however, he had went out while selection committee minutes for registrar post was considered as usual practice. There is no material whatsoever before this court to support such contention. Para 22 of the said affidavit reads as under quote unquote page 9. Such bold statement in the affidavit in opposition, unsupported by any documents, cannot be accepted. It is clear on a bare perusal of the minutes in question that the respondent number 6 was very much present as a member therein. There is nothing to show that he had walked out during the time the members of the meeting was considering the recommendation of the Executive Council for appointment to the post of registrar. In fact, the materials placed on record undisputedly indicates that it was the respondent number 6 himself who has not only participated in the appointment of in approving the nomination of the executive council expert councils, but also corresponded to them the appointment of their nomination, and has also approved the resolution of the 66th Executive Council meeting. Such participations undoubtedly cannot be said to be have been seen to have been sorry, can you just cancel that last sentence? In the event of such eventualities, the selection process cannot be said to be seen to have been done in a fair and transparent manner. Justice is not what is done, but what is seen to have been done. The learned counsels appearing for the respondents are correct that the expert counsels were nominated by the Vice Chancellor, and it was the respondent number 6 who communicated the same. But be that as it may be, there is no denial to the fact that the respondent number 6 has made those communications, approved the resolution, participated in the 66th Executive Council meeting by presenting himself therein as a member. That being the position, I do not find the selection of the respondent number 6 and appointment thereof as registrar to be done in a fair manner. Accordingly, the impugned appointment of so and so cannot stand in the scrutiny of the eye of law. Hence, the impugned appointment order dated 19/11/2025 24 stands set aside and quashed. Yes, anything more?
So, my lord, there was, in the beginning when your lordship was talking about the Mizoram Act, lordship had used the word rule instead of section. Because it's an act, I think it should be section.
No. Oh, it's an act.
It's an act, my lord. That's-
Mizoram Act.
Yes,
Correct.
yes, yes.
Correct. So if I have, wherever I have said 14, those will be section 14. Correct?
Yes, correct, my lord. That is one.
14 would become section 14. Okay? Okay. It's not rule, huh? Act and then the statutes. And 4 should be statute 4.
That's statute.
And that I said clause,
I think that would be correct.
sub clause of statute 4.
My lord, that part I'm not sure, but the first part I was able to
Okay.
remember. My lord.
I'll edit it.
Yes.
There'll be a little bit. The final relief is that dismiss. I have set aside.
Yes.
So they are. Should I mention that they are now at liberty to then they are at liberty to do whatever they want to do.
Yes. But if it's spelled out, my lord, I think it might be.
Miss Ruth, future course of action.
Yes, Lordship, if if possible, then
It is, however, clarified that the Mizoram University are at liberty to start the process afresh. No, if I say that, they might have to give the right from the advertisement. Actually, this whole process can start again.
Yeah, no, the only problem, my lord, is because the advertisement has a specific date. Within this time, you have to submit your application and also.
It is needless to be clarified that the respondent number 1 to 5 are at liberty to do the needful in order to make fresh appointment to the post of registrar in accordance with law.
Yes, and one last, my lord. Lordship had also used the word expert committee. I had noted down.
Council.
It's supposed to be, my lord,
Council.
external experts.
Oh, sorry. External expert council. No, not council.
No,
external
council,
experts.
just external experts.
Sorry.
Yes.
External experts. See, Mr. Joseph, that's why I generally prefer
Yes.
giving the dictation immediately.
Correct.
Because then, and I don't know, but I have a habit of just going with the flow and giving the dictation.
Yes.
So this break, it becomes difficult. But anyway, I try to incorporate all the arguments of both sides.
Yes.
I think everything is covered, isn't it?
All done.
All right. Enjoy your holiday
Thank you,
tomorrow.
Lordship. Same to you.
Hmm.